Okay, we're going to start. I wanted to go back to the Hobby Lobby case for one moment because there's another broader point about this case that I should have mentioned, actually two broader points. One is that civil liberties issues invariably involve conflicting claims about individual rights. One party saying it has some kind of right that ought to be protected, and another party who has a different view, also claiming that they have rights that need to be protected, and often, which is why they're in court, these rights or so-called rights seem to conflict. The Hobby Lobby case offers a nice example of that, because what we have is two alternative claims made before the court. On the one hand, the folks who went to the court or in court said, the Affordable Care Act ought to apply in this particular case, basically are arguing that the employees of Hobby Lobby and other privately held for-profit companies and their families have a right to benefit from a federal law. And that law enables them to get health insurance as provided under the Affordable Care Act passed recently by the Congress. The Hobby Lobby and those who supported its position are arguing for the religious rights of a business and a business owner. And so there's a conflict about the rights of business owners on the one hand, or what they claim to be their rights, and as opposed to the rights of individuals and families who are either individuals who are employed by the company and their families. And so one of the critical questions in the case is not really a First Amendment issue, except it is in the sense that the question becomes, does a company have a religious liberty right at all compared to the various rights of the individuals who are employees of the company? So again, this is also an example of the competing rights claims that often appear in court cases dealing with one or another of the Bill of Rights. I now want to go back. I want to start and do the rest of the amendments today, or get as far as I can. And any comments or questions before we get into that? Well, I said earlier that Bill of Rights issues, civil liberties issues, are very controversial, perhaps none more controversial than the Second Amendment. It's on the slide that you can see. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So that's the amendment. Amendment 2. There are many legal questions that remain unsettled even after two recent 5-4 Supreme Court rulings, and I want to review two of these rulings with you. The first is the Heller case. I'm not going to go through all the verbiage. The bottom line is that the local government of Washington, D.C. passed a handgun ban, and also passed an ordinance that required that those with guns have a trigger lock. And the court ruled in Heller that this law, this local ordinance, was unconstitutional. a violation of the Second Amendment. 2 years later, in McDonald v. Chicago, the Supreme Court did what we've been talking about earlier, which is it ruled that the Second Amendment it is now incorporated by the 14th Amendment due process clause, and it applies to the states. We talked about the incorporation process taking many, many, many decades, and the McDonald v. Chicago decision says that, in fact, the Second Amendment now applies to state and local governments with respect to gun ownership. What precisely that means, we'll find out in subsequent cases. I wanted to call to your attention it might not stun you to know that I oppose both of these Supreme Court decisions. I want to read to you the preamble of the Constitution of the United States and then present some information. The preamble again says, "We the people," I'm going to skip around, "in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity," and so on. So those are the plain purposes of the Constitution as the framers set them out. Since I'm sure you all know about the Newtown school massacre in Connecticut, I believe it was in December 2012. My granddaughter, my only granddaughter, lived 1 hour from Newtown at the time. Since in the year after the Newtown massacre, about 200 American children were killed by guns. During that same 1 year period, there were 26 school shootings. And so one can reasonably suggest, I think, that there's some public safety, some public health, some public welfare, some domestic tranquility issues involved in the question of gun ownership. And I would suggest, too, take a look at the specific plain language of the Second Amendment. The term "well-regulated" is the first meaningful those are the first two meaningful words in the amendment. And nowhere does it talk about individual rights. It talks about the security of a free state, meaning domestic order, public safety, the right of the people to keep and bear arms shall not be infringed. We need, too, to think about the context in which the Second Amendment was written. And that context was, first of all, we had just come through a war for independence. We still were on a continent where Americans were fighting and killing Native Americans. We were pushing west slowly but consistently. There were millions of slaves. No one, I think, could reasonably suggest that the framers intended slaves to have guns. For that matter, it's not clear that they intended for women to have guns, since they didn't have any other rights. Why would they have a right to have guns? And there's a good bit of evidence that suggests that one of the reasons the Second Amendment was put in the Constitution was so slaves could be kept under control. Further, at the time, states lacked the funds to pay war debts. We talked about this earlier. One of the reasons we have the Constitution that we do is because after we broke from Britain and won the War of Independence, the states didn't want to pay their war debts, and so they lacked revenue. And they not only lacked revenue, but because they lacked revenue, they didn't have what we would now understand to be a national guard for the individual states. And so the Second Amendment, too, I think needs to be understood in that context. And so this is a very controversial question, and I think it's probably fair to say that the state of the law is this. Some kinds of regulations of weapon possession and ownership are constitutional. Others likely are not, at least at this time. That can change over time. And we don't really know exactly what kinds of regulations will meet the test of constitutionality by this particular Supreme Court. There's reason to think, for example, that background checks, that laws that prohibit people who have committed felonies from possessing weapons or owning weapons, those probably would stand up. Beyond that, it's a crapshoot. The right to privacy. The right to privacy is a very interesting, provides, again, a very interesting and controversial backdrop. Is privacy mentioned in the Constitution specifically by using that word? The answer, no. However, the Supreme Court has found that in fact there is a zone of privacy or a concept of privacy that's implicit in Amendments 1, 3, 4, 5, and 9. One argument that's not often made is this, and that in defense of the right to privacy. Americans say, Americans pretty much of all political stripes say that they believe that a capitalist economy is a good thing. May have some difficulties here and there, but most people, most of the time, will say that's a good thing. I don't see how, if there's no right to privacy, I don't understand how private property and the private activities of businesses can be maintained. And so that's an argument I haven't seen much of, but I'll just throw it out there. So where does the right to privacy, other than the First Amendment, the right to have one's own, religious belief, for example, where does the right to privacy come from? Well, in Amendment 3, no soldier shall in time of peace be quartered in any house without the consent of the owner, and in wartime only in a lawful manner. So one's home, one's residence, can't just be invaded and occupied by, police forces. You might say, well, gee whiz, this never happens. Actually, I have a friend who's an elderly gentleman whose home in England, an island off of England, was occupied by the German army in World War II. It is possible. It happens in areas of Israel too often. Amendment 4, so it is something that's possible. Amendment 4, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and there has to be probable cause for a warrant to search to be issued. So the police aren't supposed to be able, under the Fourth Amendment, can't just willy-nilly out of the blue knock on your front door, knock it over, guns drawn or not, and start ransacking your house. Amendment 5, no person shall be compelled in any criminal case to be a witness against himself. The government can't force you to say anything. that would be legally harmful to yourself. You have the right to remain silent. You have the right not to incriminate yourself. And finally, Amendment 9, the enumeration of the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Very vague language. Reasonable people can disagree about what those rights that are retained by the people are. And so that language itself can become a focal point for cases regarding civil liberties. So one of the earliest mentions of the right to privacy is in Griswold v. Connecticut in 1965. And I might get a detail or two wrong on this, but this is almost 50 years ago. And the state of Connecticut had a law that said that, I believe what it said is you cannot, one cannot counsel people with respect to contraception, and I think there were even provisions in the law against certain contraceptive uses. Not positive on that. In any case, Griswold v. Connecticut said, hey, man, wait a minute here. The issue of relations, sexual relations between people and what kinds of protection they use is a very individual one, and we're now talking about people's bodies, and the state shouldn't be able to regulate or prohibit certain kinds of very commonplace activities. Keep in mind, too, that this is about a couple of years after the contraceptive, oral contraceptive pill has been on the market. So the idea of privacy was drawn from those amendments and then applied to this particular case. Obviously, the body is a much more private thing than, you know, one's house or one's cell phone. Abortion. The Roe v. Wade decision in 1972 is very well known. The decision in part is based on this idea of privacy and privacy rights. But the decision itself is widely misunderstood. And I'll take a minute just to talk about it. Basically what Roe v. Wade did was to say, yes, women have a right to privacy, and they have a right, and that right is pretty solid constitutionally in the first trimester of pregnancy. In the second and third trimester, the rulings says the state has some legitimate interest, and in the second trimester it can be regulated, and in the third trimester perhaps it can even be prohibited, depending on there's all kinds of provisos in there that really is left open to state and local laws. So the decision says, well, women have a right to an abortion in the first trimester. As we move into the second and third trimesters, it gets shakier and shakier because other parties, including the state, have rights as well that need to be better established under the law. And so, again, coming back to Bardis and how the Supreme Court has the final word on all kinds of issues, not really true. In other words, Roe v. Wade is a perfect example of how court decisions leave open all kinds of subsequent legislative and judicial action. And so what Roe v. Wade did was not settle an issue, but rather introduced an issue which basically had been prohibited in most states by law, introduced an issue which then has led to huge political conflicts, obviously, in the last 4 decades, and a raft of state and federal laws regarding abortion. So rather than ending political conflict or questions of constitutional meaning and application, the decision did just the reverse. On page 74 of your text, if you brought it, you can find amendments 4 through 8. And I don't know what page 134 is. I will look quickly. Okay, that's the rights of the accused. Okay. So we're now into issues of the rights of those charged with a crime. I wish I had a dollar bill for every person who has said in the past 40 or 50 years that the reason we have so much crime in the country, or one of the reasons, is because we have liberal judges who are coddling criminals, don't respect the rights of victims, and they just coddle criminals. Please, this is ridiculous. Ridiculous. The people who wrote down protections for those charged with crimes are your and my founding fathers. A good bit, if you read amendment by amendment in the Bill of Rights, what you see is one protection after another for people who are charged with crimes. Why did they do this? Well, because of their own experience in part, and because they were concerned that government could use its power to take away the liberty of individual citizens. And so they said, you just can't come in. This is Amendment 4. The cops just can't come in. The police just can't come in and search and seize your property or your car. You can't just be driving down the street perfectly legally. They stop you, and then they, whether you like it or not, they search your car. They can't do that. Okay, and the Mapp v. Ohio case established what's known as the exclusionary rule. When authorities obtain evidence through illegal searches, it can't be used in state and federal trials. Now, subsequent court rulings may have watered this down a bit. That is to say, rulings like, well, yeah, the search may have been illegal, but if they could have found out the information other ways, maybe it's not so illegal. And again, one of the tensions in civil liberties law and the reality of civil liberties is that there's this constant struggle between those who want to protect individual rights and those who side on the case of who are on the side of quote unquote order or the police authorities. Another important case from the 60s, the Miranda case. You all know what the Miranda warning is, even if you've never heard that term, because you've seen it on TV cop shows. You have the right to remain silent. Anything you say can be held against you, et cetera, et cetera. You have the right to an attorney. The language of the Miranda that's the language of the Miranda warning. Your police, when they arrest somebody, are legally obligated to explain the rights of the party who's being arrested. In practice, the police can say, I don't know, I'm trying to think of the show right now, and I can't, but in practice, many times the police will say, well, one of my favorites was the closer. Okay, these are your rights, now tell us what happened. It'll go better on you if you tell us. And so you can give the warning, police authorities can give the warning, but say, you know what, you really better, you better spill the beans here. That's legal and common. But the Miranda warning, again, is a protection against self-incrimination. The rights of the accused. The key case here is just over 50 years ago, Gideon versus Wainwright. This may come as a shock to you, but before 1963, before this ruling, people who were arrested and tried for a felony in state and local courts did not have the right to counsel, did not have the right to an attorney. If you didn't have a whole lot of money and you were charged with a felony, you were in deep trouble because you were your own lawyer. And that's the definition of big trouble. So Gideon v. Wainwright says, no, people who are charged with felonies in state and local courts have to have some kind of legal counsel. And that's where you begin to get public defenders, programs created, and legal services under the Johnson administration and so forth. Then there's finally the issue, this is out of Amendment 8, the prohibition against cruel and unusual punishment. So what does that mean? Well, in part what it means, I think, is that the state can't inflict on the body very painful blows or action. In practice, the death penalty remains legal in the United States as a whole, though we'll see a map later on that shows that some states prohibit it. But almost all countries in the developed world have, in fact, eliminated the death penalty. Federal courts in the United States have supported limitations to the death penalty. If you're 14, the Supreme Court says, well, you know what, you can't do a death penalty on a 14-year-old. If you have mental disabilities of one sort or another, the courts will sometimes say, no, you can't do that. That it's just simply cruel and unusual because the person didn't have the mental capacity to understand. But this, again, this is still up in the air, and for the most part, and recently the case of the botched death penalty application in Arizona raised the issue again. There's also related issues of can the how do you test if a state is going to use the death penalty and the state privately gets medications or drugs to administer the death penalty? Well, there seems to be some problem there, and there's issues of transparency and so on. The bottom line facts based on empirical research, as far as we know at this time, suggest that there's no significant deterrent factor between states that do have the death penalty for various crimes as compared to those that don't. And while this may seem counterintuitive, the evidence also is that applying the death penalty actually is more expensive than putting somebody in prison for life. I know that's counterintuitive, but that has to do with the length of time and the number of appeals and the costs associated with the application of the death penalty, and those laws are in place in part as a reflection of laws regarding the process and giving full rights to those who have been convicted is, I think, consistent with the spirit of the framers. So there are all kinds of racial disparities in the criminal justice system. This is a long laundry list of some of those disparities, whether it's racial profiling, whether it's the application of police, the work of police in the so-called war on drugs, the nature of police behavior, arrest rates, drug arrests, the fact that blacks are disproportionately lower income means that poorer people, and often their minority, are going to be in jail after their arrest because they can't make bail. Jury exclusion. It's not uncommon for prosecutors to do what they can to remove minorities from juries and jury pools, juries, or prospective jurors who are racial minorities. Public defenders. My daughter was a public defender for 5 years. Their workload, their caseload is huge, and it's very difficult to give full and competent defense to those who rely on public defenders because their attorneys have so many cases to deal with. Plea bargaining. There have been lots of cases of studies of plea bargaining over the years by criminal justice public agencies and academicians. And generally speaking, and this is not false, generally speaking, the most people in the criminal justice system assume if you've been arrested, you're guilty of something. They may not get what that something is right, but you're probably guilty of something. And in fact, there are empirical studies that indicate that if you are so brazen as to believe in innocent until proved guilty, well, guess what? The research suggests that's not the way the system works. It's you're guilty, we just may not quite know what it is you're guilty of. And the reason plea bargaining occurs is first because so many people are arrested and charged that it helps the criminal justice system work more efficiently. And if you take the time of the court to go to trial, the likelihood is if you're convicted, and you probably will be, that your sentence will actually be longer than if you had copped a plea. There's research that shows that black defendants receive longer sentences for the same crimes that white defendants receive. The majority prison population, just a study released that shows that black males are 6 times more likely to be incarcerated than white males, that Latino males are 2.4 times more likely to be in prison than white males. And basically what in order to make sense of this, one has to conclude either A, black males and Latino males are simply more likely, for any number of reasons, to commit more crimes, or something else is going on in the criminal justice system which is, at least in a significant measure, responsible for these racial disparities. The juvenile justice system is another mechanism of racial disparity. Racial disparity exists also in employment discrimination after release, and the application of the death penalty is grossly racially disparate. The number of white people who are put to death for killing a black person is a very, very, very small percentage of the opposite. The number of blacks who receive the death penalty because of killing or being convicted of killing a Caucasian. So one of the things that we need to understand about the criminal justice system is, in theory, the accused have rights. In reality, they're difficult to maintain in the criminal justice system. There have been all kinds of wonderful studies by sociologists and criminal justice academicians on the criminal justice system as a bureaucracy. And I'll just give you an analogy. When I was a freshman in college, the university administration would say, hey, look, we, the administrators, we're here forever. We are the university. We make pretty much the rules of the university, and we enforce them. You, on the other hand, are passing through. You're passing through. In 4 years, maybe 5, if you're not so fortunate, you'll be graduated, and you'll be doing something else. You'll be going away. They forgot that alumni give money to universities at the time. They soon learned better. So you're really not as important. You're kind of being processed through this institution, you students. And so your rights really need to be understood by the needs of the institution. And the same kind of argument comes out, the same kind of findings come out of research regarding criminal justice systems, that they're in fact bureaucracies, and that the people who work there in them every day basically determine what happens, and the defendants are passing through. I want to move on to the work of the sentencing project. There's all kinds of research as well about police work and various kinds of community policing and so on that I think indicate clearly that the rights of the accused are, especially minority accused, are problematic in many jurisdictions. There is, in the last couple decades, something called the Innocence Project. And the Innocence Project, there's a website which I've indicated in the heading here. So far, the Innocence Project has found that at least 317 people have been exonerated on the basis of DNA evidence. And 250, in other words, almost 20, more than 15 to 20 a year are found innocent based on new DNA evidence that couldn't be obtained scientifically when they were convicted. And 18 of those people were served time on death row. Another 16 were charged with capital crimes. The average time served of the people who were found innocent was 13.5 years. The total for over 4,200. The average age of the exonerees at the time of their wrongful conviction was 27. It was roughly more than 2/3 African American and Latino. Almost half of the cases were subsequently solved in some measure through the new DNA evidence. And often, though not always, these people are, once they're released, are given some kind of compensation by the states in which they were imprisoned, in which they were found guilty. And 30, in other words, nearly 10%, actually, of those who were exonerated actually pled guilty to crimes they didn't commit because their confessions were forced. And so, one way to look at long prison sentences, and I mean, can you think of anything that more deprives people of their civil liberty than a death sentence wrongly implemented, or life in prison wrongly implemented? So the death penalty is still legal in about 34 states, but there's been a decline in the number of executions, in part because there's also debates about how to do them. There are some provide for time limits for death row appeals. The methods of execution, again, that's a debate. State governments are the ones who generally apply the death penalty. There are also laws governing the application of the death penalty in the courts, or decisions for juries to recommend the death penalty. The way it tends to go is that there's a bifurcated process in the court in some states, and basically the process is this. First, you have a trial, and the question is there guilt that can be determined and found by a jury or a judge in a case where the death penalty could be a penalty. Then there's a totally new second trial to determine what that, or process to determine what that penalty should be. And so that's that's one way that many states do the death penalty in court. Here's a map of the states and the death penalty with execution since 1976 and the size of the population currently on death row. This is roughly through 2012, and from 1976 to 2012, a roughly 25-year period. You can see that the darkest states are the ones where the New York and Nebraska, where their state laws regarding the death penalty have been ruled unconstitutional. The green, bright greenish states do not have a death penalty, and the remaining you can see do. The kind of blue color that these states have the death penalty, and you can see that the states with the largest number of executions by far is Texas, and the states with the largest number of people on death row are California, Florida, Alabama, Georgia, Arizona. So there's, again, this is an example of federalism. Most applications of the death penalty are at the state level in violations of state law, not federal law. And there's differences between the states. Roughly a third of the states have no death penalty. The other 2/3 do. And so this is an example of federalism at work. You can see Illinois, for example, has executed 12 people, but none are on death row because I think the governor has said he doesn't want to do them. Life in prison sentences for juvenile offenders. There are several thousands of young people who were convicted of crimes while they were under 18, and they are now serving life without parole. The darker the state, the greater the number of people. The bright green states have fewer juveniles serving life sentences. You can see, if you're 15 and you're convicted of a crime and you're sentenced to life in prison, that's pretty tough. And I'm not sure, I know there are several thousand who are in that situation. Since 9/11, there's been a renewed focus on the debate between civil liberties and security. The most common that you would find in day-to-day life is all of the cameras that are around. But There has been anti-terrorist legislation, the Patriot Act, roving wiretaps, national security letters, the work of the National Security Agency and its surveillance, the FBI, more vigilant, the CIA, and so there are in fact many, there are numerous, more than a dozen, probably closer to 24 federal intelligence agencies, many of which work within the borders of the United States. We know that from the Michael Brown case that the Defense Department has been giving unneeded military equipment to local police agencies all over the country. So there are a variety of security issues that 9/11 has brought to the fore. Among the most visible is the plight of immigrants and immigrant detainees. We have somewhere between 30 and 35,000 immigrants who have not committed or been convicted rather of any crime, but who are essentially jailed in the United States right now. And they remain there for some time, and they have very few, if any, rights, apparently, under the Constitution. And finally, one can legitimately ask, is there any privacy anymore in the internet age? And so I've posted this, if you're on Twitter, if you're on Facebook, if you're anywhere online at all, and I suspect most, if not all of you are, what you do, who you are, can be tracked. And this website is a compendium, an inventory of various kinds of privacy resources with respect to the internet. Let me close by saying that there are also advantages of and lessons to be learned from this new technology. There's an article this morning that I read that's very interesting. I'll try to make it brief, but they pay me by the word. 15 to 20, 20-something young white people go to a restaurant in Philadelphia, I guess last week. They're having a good time. They're all dressed up nice. They, upper middle class kids by all appearances. And they get out of the restaurant after eating their meal, and they walk in apparently groups of 3 down the street in Philadelphia. And they happen upon 2 men in their late 20s who happen to be, at least to them, they appear to be homosexuals. And these 20-some people, men and women, begin to beat up and actually physically harm at least one of the 2 men and rob them. These are, by all appearances, upper middle class kids, young people. And they just beat the living daylights out of these 2 guys. Well, somebody took pictures of them in the restaurant. Somebody took pictures of them on the street as they were walking down the street, the same street where the attack occurred, posted them on Twitter. Tell us what restaurant this is, tell us what street this is, and the Twitter sphere provided the information. It was turned over to the police, and these people are going to be charged with a hate crime, probably with robbery, probably with assault and battery. Well, I suspect they won't do that again for a while. So there is a, the invasion of privacy, if one can call. Well, I mean, one can argue whether or not, if you're in public beating people up, that you have any privacy right at all, or even just walking down the street. One can argue that you don't have any privacy right. But very clearly, social media and the widespread availability of cameras and the video that and images that they produce is a significant societal change. It affects not only individual privacy, it affects all kinds of things. Have a good weekend. Don't forget your papers are due on Sunday. And read Chapter 5. Take care.
Can you ask me a question?